All right, good day, ladies and gentlemen. My name is David Gold, as you all know, and welcome to Coke Radio and Television Stations. Station where we're giving a back-to-back as the hot. Still on this same election matter, election petition, and also tribunal. And finally, it has come to our hearing that APC lawyer has finally addressed the court on the issue of the drug cases in US concerning the president-elect Bola Ahmed Tinubu. The lawyers of APC has finally declared to the court that, in nutshell, that this court case has no weight or value of disqualifying Mr. President Bola Ahmed Tinubu, that it is not enough reason to disqualify His Excellency Bola Ahmed Tinubu. Now, let's watch this video and see how this analysis go on this matter.
So Tinubu's lawyers have put in their final written address in defense of Tinubu at the tribunal. And they're saying many things, some of which are just purely false. The one that struck me out of them most is the fact that they are claiming that the US drugs case against Tinubu in the US is not sufficient ground for Tinubu to be disqualified. They are still claiming that there was no conviction and there was no sentence of fine. That's what they are still claiming. And I am surprised because these are supposed to be senior advocates of Nigeria. I am surprised. Tinubu's lawyers are actually now saying that, yes, they agree that it happened, but that there was no conviction. Oh, that it was a civil process, that there was no fine. It was just forfeiture. Now let's look at this. Was there a conviction? Was there a fine? In the final order, from the court documents, this is not according to me now, no. According to the court documents, in the final forfeiture order, the court, through the presiding judge, ordered. Now, when you hear ordered, it means that it is a decision reached by the court and a proclamation made by the court based on the evidences presented before the court. The court, the judge, in that case against Tinubu, ruled. He gave his judgment. He gave an order declaring that the money in question in Tinubu's account represented proceeds of narcotics trafficking. Recall that there were two charges against Tinubu: violation of US Code 1956 and violation of US Code 1957. Now, these two bordered on money laundering and making money from illegal means or unlawful activities. Unlawful activities include drugs trafficking or narcotics trafficking. Now, looking at the court order, the final forfeiture order that was made against Tinubu in the US, let's ask ourselves two questions. Number one, was there a conviction? Number two, was there a sentence of fine? Now, to answer the question, was there a conviction, we need to first of all define what a conviction is. Obviously, what the Tinubu lawyers or Tinubu's defense team is trying to make Nigerians believe or make the court believe in their final written submission is that if there was a conviction, then there would have been a photograph of Tinubu that is in the archives of the court to prove that he was actually convicted. Now, this is shocking for me because these are senior advocates of Nigeria. I would assume that they understand the basics of what a conviction is. A conviction, if you look through lawyer or legal dictionaries and conventional dictionaries, Conviction is a simple decision reached by court or by a jury. A simple decision reached by a court, by a judge, or by a jury is a conviction. And the opposite of conviction is acquittal. And a conviction, which is a decision reached by a judge or a jury, is reached having analyzed the evidences before the judge or the jury. They reach a decision. That decision will either be a conviction or an acquittal. In the case of Tinubu, looking at the certified true copies of the court documents in the final forfeiture order of the court in Chicago, we look at it. The court, the judge, ordered that the proceeds, the amount or the funds in Tinubu's account represented proceeds of narcotics trafficking. That was a decision that the court or the judge reached based on the case before it. And what was the case? A case was brought against Tinubu in a verified forfeiture claim, backed up by a sworn affidavit that Tinubu was in possession of funds that represented proceeds of narcotics trafficking or drugs trafficking. That was the case before the judge, before the court, having given Tinubu his right of fair hearing to defend himself. And of course, Tinubu, ably represented by his brother and some other persons. The evidence presented before the court reached a decision. And the decision that the court reached was that Tinubu was indeed guilty of being in possession of funds that represent proceeds of narcotics trafficking. He was not acquitted. He was convicted. Now note that a conviction in this case is a decision reached by a judge or by a jury in a case that is brought before it after or having analyzed the evidence before it. It is not a conviction. Conviction should not be construed to mean only taking photograph of the person and snapping it and sending the person to jail. No. Conviction can actually be a decision that is reached, first of all, to confirm that a person is guilty or acquitted. Guilty or not guilty. In this case, the decision of the judge was that Tinubu was indeed guilty of being in possession of funds that represent proceeds of narcotics trafficking. The order indicated that Tinubu was guilty. Now that is a conviction. Now what is a sentence? Once the court is convinced, once the judge or the jury is convinced, in this case the judge, that Tinubu was indeed guilty of violating US Code 1956 and US Code 1957, it now proceeded to issue a sentence. Now, if you look at the US Criminal Code 1956 and 1957, the prescription for punishment for violating those codes are there. For US Code 1956, it is either a sentence of fine or a sentence of imprisonment. The same thing for US Code 1957, a sentence of fine or a sentence of imprisonment, or both. But in the case of Tinubu, the judge, having found Tinubu guilty, having convicted him of being guilty, having reached a decision that Tinubu was guilty of being in possession of monies that represented proceeds of narcotics trafficking, drugs trafficking, he now proceeded to give a sentence of fine. The recommended fine maximum is $500,000 and or 20 years in prison, or both. So the judge ruled or gave a sentence of fine of $460,000 US, which is less than $500,000 prescribed as punishment for violating that US Code 1956 and 1957. So there was a conviction. The judge reached a decision that indeed Tinubu was indeed guilty by having in his possession, through his account, monies that were linked to narcotics trafficking. That's one. And then he proceeded to give a sentence of fine as prescribed by the US Criminal Code for violating US Code 1956, which is a sentence of fine of not more than $500,000 US. So, going by the US justice system, the US legal system, and analyzing the certified true copies of the court documents, it is clear that Tinubu was convicted and was given a sentence of fine of $460,000 US, which he forfeited. Now, the reason he forfeited it was because the money was already seized. The first thing that the special agent Kevin Moss did was to file an affidavit and then file a verified complaint for forfeiture, which the judge used to freeze the account of Tinubu, because he could actually withdraw those money and use the money to buy real estate, thereby covering his tracks. So the money in the account was quickly frozen. And having concluded the case, since the money was now in the possession of the US government, the judge now ruled that, okay, since he has sentenced them to a fine of $460,000 US, that money should be removed from the account and the excess refunded back to those people who claimed the money were theirs. People like the brother to Tinubu. So there was clearly a sentence of fine. There was clearly a conviction of guilt as a decision reached by the court in that case against Tinubu in the US in 1993. Since there was a sentence of fine, let's bring that into Nigerian law. According to the Constitution of Nigeria, Section 137, subsection 1D, Section 137 actually covers conditions for disqualification of any candidate to run for office of president of Nigeria. And subsection 1D particularly talks about, number one, sentence of death or sentence of fine or sentence of imprisonment. Three things. It talks about a sentence of death, it talks about a sentence of fine, and it talks about a sentence of imprisonment. For the case of sentence of death, that has to be given by a court in Nigeria, because there are certain crimes that attracts the death penalty in other countries that actually do not attract the death penalty in Nigeria. So the sentence of death must be issued in a court in Nigeria. But for the sentence of fine and sentence of imprisonment, those two sentences do not have to be issued by a court in Nigeria. In fact, it says that once it is issued by any court in any country, any part of the world, so far as anybody has been under a sentence of fine or a sentence of imprisonment for anything relating to dishonesty or crime, that person stands disqualified. There is nowhere it states that that judgment needs to first of all come and be registered. No. There's nowhere it states that person needs to first of all come and be registered. And in fact, according to the Electoral Act 2022, it doesn't require the evidence of such sentence of fine or sentence of imprisonment to first of all be registered first. The conditions are clear according to section 137, subsection 1D of the Constitution of the Federal Republic of Nigeria, 1999 as amended. So it is clear that Tinubu is not qualified. Now, for those of you out there saying that, oh, everybody is now a lawyer, everybody is now a lawyer. Look, let me say this to you. A citizen of a country like Nigeria does not need to be a lawyer to understand the Constitution of Nigeria. A citizen of Nigeria does not need to be a lawyer to understand the Constitution of Nigeria. It does not. In fact, every citizen of Nigeria is encouraged to read and study the Constitution of Nigeria so that they can know how to conduct themselves. Every citizen. In fact, it will shock you to note that the Constitution of Nigeria even allows somebody who is indicted in a criminal case to represent himself without even a lawyer. The Constitution allows it. So coming to say that, oh, everybody is now a lawyer in this case, and everybody is interpreting it in their own way, you people should be happy that Nigerians are paying attention to the legal process, to the Constitution of the Federal Republic of Nigeria. You should be happy. It should be a thing that should be applauded, that people are now paying attention, and stop making it look like it's something that should not be done, and trying to derogate, look down upon people who are trying to interpret the Constitution, which is actually done in plain English. Trying to make them look like, oh, they are not lawyers, so they cannot interpret. Please. Everybody is free to read and study the Constitution of the Federal Republic of Nigeria and to interpret it. Yes. So the fact that in this petition of Peter Obi, we are now having many Nigerians come out to actually look at the process. Before now, we have not actually looked at the process. That's why they could do anything and get away with it. But this time around, it's not just hashtag all eyes on the judiciary. It's on the entire process. People are paying attention. So you should be clapping and applauding them for paying attention to the process, not trying to dismiss them by saying they are not lawyers. So it is clear. The Constitution of the Federal Republic of Nigeria is clear. And one thing that still gives me joy is the fact that they are no longer arguing that Tinubu was involved in a drugs-related case. He was involved. He was involved. Now, they are no longer contesting the fact that Tinubu was actually linked to a drugs trafficking case in the US. That's no longer argument. So for those of you who are supporting Tinubu and saying that, oh no, it was a lie, Tinubu was not involved in any drugs case, his lawyers have admitted that yes, he was indeed involved in a drug trafficking related case in the US. They have agreed. On this, there's no argument. Both the Tinubu's defense and the Labour Party's defense, everybody agree that there was indeed a case against Tinubu in the US. They agree. And that it was related to drugs trafficking, based of course on the certified true copies of the documents that are out there in public domain. So it is no longer in question that Tinubu was involved in drugs related case. Now ask yourself, let's even take this argument away from the moral ground, from the legal ground. Let's take it to a moral ground. We have Yahoo boys that are being hunted down by the DSS, by the EFCC, by the police, by SARS and all that. We have criminals that are being hunted. We have even drug dealers that are being hunted by the security agencies. We are trying to discourage the youths, even from a religious perspective, from being engaged in drugs. And then you have somebody like Tinubu who has been involved in drugs before. He's not even coming out now to apologize. He's not even coming out to say, oh, he did it in the past, please forgive me. He's not even saying that. It's even annoying enough that he's not even talked about it. He believes he can buy people, buy SANs, senior advocates of Nigeria, to speak and defend him and To hell with Nigerians. It's disrespectful to the entire population of Nigeria that he has not even come out to say sorry. He should come out to say sorry. Because right now we are not even arguing that the event happened. We know it happened. For the event to even happen at all, before we even start talking about even qualification or no qualification, Tinubu should come out and apologize to Nigerians first. But he has not done that. On a moral ground, how do you, defending Tinubu, how do you tell your sons and your daughters that it is wrong to do drugs? How? How? Now, for whatever monies you think that you're going to make, know this. The election season will soon be gone. It should be done, to be done away with. In another 2-3 months, maximum, the matter would have been ended at the Supreme Court, and whatever change that you got as a lawyer from this process, you would have finished spending it. Look at what Tinubu is doing to Nigeria. How the conditions of living is hard for Nigerians. That money will not carry you for another 1 year. And then you will come to the point where you start suffering the consequences of your actions. Think. Put justice first. Put country first. Let us create a country that works for everybody. That way, you don't need to depend on only monies that you get during election time as a lawyer before you can leave. The country will work for everybody. You make your money normally. Everybody makes their money normally. The GDP grows. And then we can all sing Kumbaya. But right now, it is not fair that you are seeing the light and you are calling it darkness.
Well, I hope you all enjoyed the video, but all I will have to say is let the judiciaries, let the court take its place and do the needful. All eyes on the judiciary. All of us gather day. We all day, they watch both day and night. We they watch all movement. We are monitoring every humanity, both spirits, body, animal form, any form. When you want to waka, we Nigerians, we are watching, and our eyes are all on the judiciary. I don't talk my own, no, and I don't close my mouth. Now, bye. Ọmọ ní ìfowóṣe ni.